judgment of Indira Gandhi, my lord, as well as the Pandit Jawaharlal Nehru, my lord, that is that I.
गांधी वर्सेस पंडित जवाहरलाल नेहरू।
नहीं नहीं, दो जजमेंट है सर। द जजमेंट ऑफ पंडित जवाहरलाल नेहरू एंड द अदर जजमेंट इज इंदिरा गांधी।
बताइए पंडित जवाहरलाल नेहरू का।
वो सर मुझको 10 मिनट का टाइम दे देते, मैं लाके दे देता हूँ।
ऐसा थोड़ा ना होता वकील साहब, ये सब आपकी बहस, आपका पक्षकार देख रहा है, आपका पक्षकार देख रहा है आपकी बहस।
सर टाइम बहुत शॉर्ट हो गया था सर, क्योंकि कल पिटीशन लगाई है और कल में सब कुछ करना था।
क्या थी उसको कल
जल्दी इसीलिए सर, क्योंकि 23 और 24 को फंक्शन है। 23 और 24 परसों,
तो सोमवार को 22 तारीख भी है, 22 को भी सुनवा सकते थे आप
सर। एक दिन में पूरी मशीनरी पूरी गड़बड़ा जाएगी, क्योंकि वो पूरा फंक्शन जो है बाहर से लोग आते हैं, सारे क्राउड इकट्ठे हो जाएंगे। 144 धारा जो लगाई है उसका कोई यूज नहीं होगा।
144 धारा हटवाना चाहते हैं
सर? मेरा 144 हटाने का उद्देश्य नहीं है। मेरा उद्देश्य ये है कि सर, कि जो वहां पे जो रिलीजियस लोग रहते हैं उनकी धार्मिक भावनाओं को सर दिक्कत होगी, क्योंकि ये सारी बातें सर, इसमें हिंदुत्व के बारे में सबसे ज्यादा वहां पे बोला जाता है, और जो सबसे ज्यादा आहत होगा ये वर्ग, और इस वर्ग के लिए
आहत होगा। लिख लेते हैं, ये भी आर्ग्यूमेंट लिखिएगा। श्री प्रहलाद चौधरी, लर्नेड काउंसिल फॉर द पिटीशनर। श्रीमती जानवी पंडित, लर्नेड एडिशनल।
मैंने सर एक सीडी इसमें पेन ड्राइव लगाई है, और इस पेन ड्राइव में वो सारी बातें हैं जो वहां पे घटित हो रही घटना, उस घटना से विरोध कितना हो रहा है इस फंक्शंस के लिए, वो मैंने एक वीडियो से दी। और मंत्री जी का इसमें भाषण
65B का
लगा है।
65B का
पेज नंबर 47।
क्या है ये? शुभम उइके जिन्होंने सर्टिफिकेट।
जी
पढ़िएगा जरा।
मैं प्रमाण पत्र जारी करता शुभम उइके, पिता श्री सुवेंसु निवासी, प्रमाणित करता हूं कि मेरे द्वारा पब्लिक मंच जिसमें रामकिशोर कावरे मंत्री जी द्वारा बनवासी रामकथा के प्रवचन बागेश्वर धाम द्वारा कराए जाने की अनुमति के संबंध में दी गई भाषण तथा आदिवासी द्वारा विरोध प्रदर्शन की रिकॉर्डिंग एवं पेपर कटिंग की फोटो अपने मोबाइल 1 प्लस जिसका मोबाइल नंबर स्वयं में किया जाकर OTG लीड्स के जरिए पेन ड्राइव में लोड कर 4 प्रतियां निर्मित की गई हैं, जो 32 GB की है, जिसका विवरण निम्नानुसार है। पेन ड्राइव के OTG फोल्डर के अंदर डॉक्यूमेंट है, जिसमें 2 वीडियो और 18 फोटो चित्र हैं। उपरोक्त कथित विवरणी मेरे द्वारा दिनांक 16/5/2023 को अपने मोबाइल 1 प्लस के लीड के जरिए बिना छेड़खानी के जैसी की तैसी पेन ड्राइव में अपलोड की गई है, जिसमें कोई रद्दोबदल किए गए रिकॉर्ड की है। कथित मोबाइल का मैं मालिक हूं तथा मेरे वैध संरक्षण में सुरक्षित है, जिसे कुछ भी काट-छांट नहीं की गई है और ना ही कुछ जोड़ा गया है। अतएव यह प्रमाण पत्र माननीय उच्च न्यायालय के समक्ष प्रस्तुत पेन ड्राइव की सत्यता के संबंध में जारी किया गया है। वहां पे सर जो विरोध हो रहा है, उस पूरा विरोध का दिया है। अब सर इतना ज्यादा विरोध के बाद भी वो फंक्शन वहां पे होगा, तो एक तो सर क्लैश कर रहा है। 144 धारा भी उन्होंने लगा कि जहाँ पे 4-5 से लोग ज्यादा इकट्ठे नहीं हो सकते, वहीं पे पूरा क्राउड को इकट्ठा कर रहे हैं, और दूसरी तरफ सर वो ऑर्डर कर रहे हैं पूरे उस फंक्शन को कराने के लिए। तो मेरा निवेदन सर ये है कि भाजपा के प्रोग्राम के लिए गवर्नमेंट मशीनरी नहीं लगेगी सर, उसमें गवर्नमेंट मशीनरी को लेने के लिए भी ग्राम सभा।
एलिगेशन कहाँ लगाया कि ये पार्टी का प्रोग्राम है? बताइए ना। पढ़ी तो आपका आर्गुमेंट
जी
बदल रहा है धीरे धीरे।
जी
आपके सुर और आर्गुमेंट दोनों बदल रहे हैं।
नहीं सर, लिखा है,
बताइएगा।
ये सर पेज 11 3.7 that the private respondent Ramkishore Kavre MLA openly stated in the public that till no such order has been passed by the government collector to organize the function of Dhiren Sastri for promoting the Hinduism, simultaneously behind back obtain the order of collector and misrepresenting the tribals of that area. The copy of video stored.
बीजेपी कहाँ लिखा है आपने कि बीजेपी का फंक्शन है? बताइए। तो आप जो बहस कर रहे हैं वकील साहब, हवा में बहस मत करिए।
सर पेपर कटिंग में जो लिखा हुआ है वो पेपर कटिंग का मैंने आपको बताया कि उसमें।
अब ऑर्डर सुनिएगा
जी,
बैठ जाइए, ऑर्डर सुनिएगा। प्रहलाद चौधरी आगे सुनना, लिखिएगा। दिस पिटीशन इज फाइल्ड इन द स्टाइल ऑफ पब्लिक इंटरेस्ट लिटिगेशन बाय वन मध्य प्रदेश आदिवासी विकास परिषद जानवी पंडित, learned additional advocate general, submits that there is no public interest in the petition. It is politically motivated. Full stop. Placing reliance on the judgment of Supreme Court in state of Uttaranchal versus Balwant Singh Chaupal, CHAUFAL, Chaufal, 2010 का 3 SCC 402 and reading para 181, it is pointed out that courts must encourage only genuine and bona fide PIL and not and effectively discourage and curb the PIL filed for extraneous considerations. Full stop. It is submitted that present PIL is loath with extraneous considerations and political motives. Next para. It is also pointed out that it is not mentioned by learned counsel in his petition that under which provision of law permission was required to be taken by the respondent number 7 from the concerned Gram Panchayat in terms of the provisions contained in PESA Act. Full stop. It is also submitted that as far as Annexure P2 is concerned, comma, that is with a view to maintain law and order because district administration is expecting a huge gathering of persons looking to the past history of respondent number 7, and it is their duty to oversee that no issues in regard to law and order are created causing inconvenience to the common man. Next paragraph. It is also submitted that another order passed by the district magistrate under section 144 CRPC is only to the effect and to educate the public at large that they should keep themselves insulated from exchange of objectionable messages, etc. on public media as that has the potential of disturbing public peace, comma, law and order. Full stop. Thus, placing reliance on the aforesaid judgment in case of state of Uttaranchal, it is submitted that there is no public interest and petition be dismissed. Next paragraph.
If I may also
After
point
hearing,
for a moment, Your Lordship, I'm sorry to interrupt. If I may also point out, this order dated 2nd May 2023 has subsequently been modified. That is, they have not challenged, as per my instructions.
when was it modified?
It was modified, Your Lordship, on that order, but on 5th of May. It is a.
Have you bought it on record?
It is not on record,
Do
but
you have-
I have a copy. I have a copy.
Srimati Janvi Pandit further submits that order dated 2/5/23 was subsequently modified by the district collector and district magistrate on 5th May 2023 and said order has not been challenged by the petitioner. Next paragraph. As far as the last submission is concerned, comma, it appears to be an order of reshuffling the posting oblique placement of officials. That does not need that does not require much indulgence in as much as 2/5/23 and 5/5/23 are administrative orders passed by the district magistrate who has a duty to maintain law and order within his district. Full stop. It only order dated 5th May 23 only makes arrangements in a different format, deploying a different set of people, and that being an administrative exercise that does not call for and cannot be interfered in the discretion in the exercise of judicial discretion of this court, as that those orders are specifically within the domain of administrative discretion vested in administrative discretion and administrative authority vested in the district collector and district magistrate Balaghat. Next paragraph. Petitioner's preliminary argument is that in terms of provisions contained in section 4 within bracket D of PESA Act 1996 and 4 within bracket F of the said act, ikhatta kar lena. The act without taking concurrence of the Gram Sabha, no function could have been organized. Next paragraph. A plain reading of provisions contained in section 4D and 4F which reads as under. ये मैं आपको ये ले लीजिएगा, इसको कोट कर लीजिएगा हिंदी में, 4 घ और 4 चा, ठीक, makes it abundantly clear that section 4D of the Act of 1996 provides that every Gram Sabha shall be competent to preserve and
If I may,
save the traditions, comma, mores, comma, cultural identity, comma, resources of the community, and for disposal of disputes in a conservative society by conserving and preserving their traditional methods. Full stop. Similarly, section 4 within bracket F provides that it is expected of every panchayat at village level, it shall oversee the implementation of the prescribed schemes, comma, programs and projects meant for the said panchayat by using by making optimal utilization of the amounts so sanctioned and obtain their certification. Full stop. Thus, a combined reading or a separate reading of provisions contained in section 4 within bracket small d and 4 within bracket small f does not bring home that there is any provision for taking permission for the Gram Panchayat to organize any religious or public function. Full stop. Thus, first limb of argument put forth by learned counsel for the petitioner that without permission of the Gram Sabha, no program could have been organized is not made out. Full stop. We have given a careful reading to Schedule 5 of the Constitution of India, which according to the petitioner will be applicable to the facts and circumstances of the present case in as much as Balaghat is a notified tribal district. Full stop. There is no provision under Schedule 5, sorry, fifth schedule to the Constitution which provides for provisions as to the administration and control of scheduled areas and scheduled tribes. Full stop. It nowhere provides that before undertaking any public function, concurrence of the Gram Sabha or Gram Panchayat is necessary.
My lord, may I submit?
Full stop.
ये
बीच में interrupt-
नहीं, एक पार्ट है सर, वो इसीलिए आपको बताना जरूरी है। ये उसी का जो 4 के आगे दिया हुआ है। अनुसूचित क्षेत्रों में पंचायतों को ऐसी शक्तियां और प्राधिकार प्रदान करते समय जो उन्होंने ये उसी के सर पेज 2 पैसा एक्ट के
पैसा एक्ट का
पेज 2 डा
डा
डा डा
डा डा कहाँ है? डा, हाँ, पढ़िए।
चौथे नंबर पे सर, 5वें नंबर पे सर। अनुसूचित क्षेत्रों में पंचायतों को ऐसी शक्तियां और प्राधिकार प्रदान करते समय जो उन्हें स्वायत्त शासन की संस्थाओं के रूप में कार्य करने में समर्थ बनाने के लिए आवश्यक हो, राज्य विधानमंडल यह सुनिश्चित करेगा कि पंचायतों और ग्राम सभा को उपयुक्त स्तर पर
पहले बताना चाहिए था, वकील साहब लिखवा देते हैं। चलिए, और कुछ बताना है तो
और-
इस बार में बता दीजिए।
और उसी का सर 6
हाँ, पढ़िए।
सभी सामाजिक सेक्टरों में संस्थानों और कृत्यकारियों पर नियंत्रण रखने की शक्ति प्रदान की जाए।
ठीक है, चलिए। ऊपर जहाँ पर अपन ने 4D और F लिखा है ना, वहीं उसको और जोड़ लीजिएगा, बता देते हैं। F के बाद में D H I J K
M, Your Lordship, I'm handing over a copy of the English version of it.
वर्जन दे दीजिए। मैंने जो ट्रांसलेट करके लिखा है ना, वो भी इंग्लिश वर्जन से सही लिख लीजिएगा। मैंने रफ ट्रांसलेशन कर दिया।
No, it was absolutely correct, Your Lordship, all the entire translation.
ये 4M भी लिख लीजिएगा, वहीं जोड़िएगा साथ में। इनका नाम डाल के some places also places reliance on clause M of section 4 of PESA Act which reads as under. It is submitted that the spirit of the Act of 1996 is that while endowing panchayats in the scheduled areas with such powers and authority as may be necessary to enable them to function as institutions of self-government, a state legislature shall ensure that the panchayats at the appropriate level and the Gram Sabha are endowed specifically with dash लगा के within bracket Roman 6 the power to exercise control over institutions and functionaries in all social sectors. ठीक है, तो इसका भी उत्तर लिख लीजिएगा. Even this argument appears to be half-baked. Full stop. The true meaning and import of clause M of section 4 is that panchayats in the scheduled area will be given sufficient autonomy to function as an institution of self-government, for which purpose autonomy will be given by the state legislature, which will ensure that panchayat at the appropriate level and the Gram Sabha are empowered with 7 functions which are mentioned below clause M of section 4. Full stop. Since Shri Prahlad Chaudhary has placed reliance on clause 6 Roman है bracket में, it is evident that it bestows Gram Sabha to exercise control over institutions and functionaries in all social sectors which are within the domain of the Gram Panchayat and not those functions which are beyond the Gram Panchayat. Full stop. As far as understanding of law goes, Gram Panchayat is not bestowed with the authority to maintain law and order in the district or within the Gram Panchayat. Law and order still continues to be the exclusive domain of the district administration under the 3-tier system of public administration. Therefore, when it is taken, it is seen from when the whole scenario is viewed from this perspective, then submission made by Shri Prahlad Chaudhary that any function which is required to be organized within the boundaries of a Gram Sabha require concurrence of a Gram Sabha is not made out because Shri Prahlad Chaudhary has not brought any material on record that to organize a public or religious function, concurrence of Gram Panchayat is necessary. Full stop. Gram Panchayat of the Gram Sabha is necessary. Therefore, even this argument is not germane to the present controversy. Next paragraph. As far as annexure P5 is concerned, it is an order passed by the district magistrate in exercise of his authority under section 144 of Code of Criminal Procedure. Full stop. Section 144 Criminal Procedure Code deals with power to issue order in urgent cases of nuisance or apprehended danger. Full stop. It is evident from the order dated 10/5/2023 that based on past experiences in regard to law and order situation and foreseeing the apprehended danger, said order dated 10/5/23 has been passed. It is preventive in nature, and that the order being preventive in nature does not provide any lever in the hands of the petitioner to twist it in such a manner to make this court hold that provisions contained in Article 19 dealing with religious and personal freedom can be controlled through exercise of said lever. Full stop. Therefore, that submission that annexure P5 is contrary to annexure P2 is also not made out. There are two distinct functions of the district magistrate. One is to prevent any uneventful happening. Second is to facilitate law and order by deputing appropriate functionaries, district functionaries, so to prevent any law and order situation. And therefore, both these orders, Annexure P2 and P5, in fact, actually supplement each other rather than being contradictory as submitted by Shri Prahlad Chaudhary. Therefore, this ground too is not made out. Next paragraph. As far as issue of political leverage and other aspects are concerned, when they are examined in the light of the judgment of Supreme Court, light of the judgment of Supreme Court in Dham and others supra, it is evident that Honorable Supreme Court in para 35 of the judgment of Dham has demonstrated that the framers of the Constitution could have made a common draft of restrictions which were permissible to be imposed on the operation of the fundamental rights listed in clause within bracket 1, full stop. But that has not been done, full stop. The common thread that runs throughout sub-clauses 2 to 6 is that the operation of any existing law or the enactment by the state of any law which imposes reasonable restrictions to achieve certain objects, comma, is saved, colon, semicolon, sorry. However, comma, the quality and content of such law would be different by reference to each of the sub-clauses within bracket A to within bracket small g of clause within bracket 1 of Article 19. Full stop. Next paragraph. Article 19 deals with protection of certain rights regarding freedom of speech, etc. Full stop. Clause A deals with freedom of speech and expression. Semicolon. Clause B deals with right to assemble peaceably and without arms. Semicolon. Clause D deals with right to move freely throughout the territory of India. Semicolon. And clause G deals with right to practice any profession, comma, or to carry on any occupation, comma, trade or business, full stop. It is not pointed out that if for respondent number 7, preaching is a profession or occupation, then how that is in conflict with the interest of the petitioners, especially the tribal population of district Balaghat, full stop. Once that is not brought out on record, then freedom of speech and expression of the respondent number 7 or right of the public of the Gram Sabha or the district of Balaghat or neighboring districts to assemble peaceably and without arms cannot be curbed merely on the basis of certain apprehensions of there being a political motive in the hands of the private respondent number 6, full stop. Such motives cannot, next paragraph, such motives cannot form backdrop of the public interest litigation. There is no material on record that any of the sentiments of the tribal population are going to be disturbed by preachings of respondent number 7, full stop. In fact, we are constrained to observe that petitioner has not dealt with and has not mentioned that what are the religious beliefs and practices of the tribal population and how they are in conflict with the preachings of the respondent number 7, full stop. In absence of any material on record, comma, when Supreme Court has itself held in case of Indian Aluminium Company and others supra that the rule of law permeates to fulfill constitutional objectives of establishing an egalitarian social order, comma, the respective sovereign functionaries need free play in their joints so that the march of social progress and order remains unimpeded, comma, this court is of the opinion that if we show any indulgence in the matter, then that will be disturbing the social fabric and disturbing the laudable object of the Indian Constitution to achieve egalitarian social order. Therefore, we refuse to show any indulgence in the matter, especially when petitioner has failed to show any violation of the statutory provisions contained in the PESA Act or Schedule 5 of the Constitution, or as to the provisions contained in Article 19 of the Constitution. Thus, petition fails and is dismissed.
No question.